A dramatic change in the handling of personal injury cases over the last 3 or so decades has been the willingness of both sides to engage in alternative dispute resolution. Even the pretrial order of the courts of the Massachusetts Superior Court asked about the parties' willingness or amenability to alternative forms of dispute resolution, and those could be arbitration or mediation. I've blogged primarily about mediations, and I will blog a little about arbitration in the course of the next few weeks. But let's talk about mediation and what can you expect. Certainly some of my blogs have spoken to that, but one thing I think you should do or should be aware of when you are about to embark upon a mediation, and of course your lawyer will be present, is what's the introduction? What will the mediator, who might be a retired judge or an experienced lawyer, what will they suggest to you as you sit down to hear and hopefully hear that your case will be resolved? First, that you will have it explained to you that mediation is a voluntary process. No side is compelled by the courts, perhaps they're encouraged, but no side is compelled to go into a mediation. Secondly, the mediator has no authority. The mediator has no ability, that is, to force a resolution down either party, and it is not only voluntary in terms of going to the process, but the resolution is likewise voluntary. You will hear a mediator say that it is usually better when the parties make the decisions themselves rather than turning it over to the court process. And that is something that is perhaps wise, but it is also said to have both parties go into the negotiation process with an open mind. And the negotiation process of a mediation is essentially done in separate rooms with the plaintiff, the person suing, and his or her people in one room, and the defendant personnel, perhaps an insurer, certainly an attorney, in the other room. And then the mediators will sort of conclude their introductory remarks by telling you that if you can't resolve the case at mediation, the system allows or will cause 12 people to decide it for you. I want to add, however, that it does not exactly happen as immediately as you may think. For if you have a case that doesn't resolve in mediation, it doesn't automatically mean you will have a jury trial with 12 people deciding. Instead, it will likely mean that negotiations could continue, and there's still that chance of a jury trial, but not necessarily as high a likelihood as you may be led to believe after an unsuccessful mediation. So all in all, I think it's often indicated and often a good process, but there is no reason to feel you have to walk out dismayed because it is voluntary. Thank you.